Hello, everyone. My name is Kanae, Japan Director of Human Rights Watch. It is such an honor for me to present this one of the most serious human rights abuses in Japan. However, I am really hopeful that together with my partners, as well as very courageous victims. And in fact, we have, three distinguished lawyers in this room who is working to reform Japan's criminal justice here. Ms. Wada, Mr. Nishi, and Ms. Yoshida. Together with the support of you, I am hopeful that this serious, rights abusive system would be reformed. As Jesper-san kindly introduced, we published, by the way, let me have this report in Japanese, Nihon no Hitojichi Shiho. We have, the original is in fact in English. The title is Japan's Hostage Justice System, Denial of Bail, Coerced confessions, and lack of access to lawyers. It is in our website, so hopefully, you can read it afterwards. But this hostage justice system is in existence for decades. In fact, as a very young lawyer, 20 years ago, when I was 5 years old, probably, I encountered this reality. I was a first-year practicing lawyer in Tokyo, and then I was called to a police station, and then I met a man who was arrested like 5 hours ago on not a serious crime, and then he thought, and he was mistakenly arrested. So he thought that if he told the truth, police would just release him, but he was not, and he was very confused. And then he thought that probably next day he will be released. He had 2 little kids and wife, and then the family was in confusion and chaos. As a young lawyer, I knew the book. I think I knew the laws then, and then by the law, the people would get bail, except for small exceptions. So I was believing that he would get bail, but in fact, he got bail only after 3 months on this very small crime. And then he was nearly fired from his company. His family was nearly corrupt. And then psychologically, he really was, corrupt in the detention. He was very, very confused. He was working for a very famous consulting firm back then. I was very shocked. That was when I realized that what was written on the law and the books and what I studied for the bar exam was completely different in reality. But rather than I speak about this reality, we made 5 minutes short video which explains this situation really well. So I wish you would watch this.
Japan is known around the world as a rights-respecting democracy that protects civil liberties. However, its justice system is facing international backlash from unjustly detaining people awaiting criminal charges. This was highlighted by the high-profile case of auto tycoon Carlos Ghosn in 2018. Ghosn was arrested on suspicion of misconduct while he led Nissan Motor Corporation. He was detained for more than 4 months on charges of false accounting without a confirmed trial date.
この問題は別にゴーンさんが特別だったわけではなく、多くの日本の被疑者被告人はこれまで同じような状況に置かれていたと言えるかと思います。逮捕された段階でもうその被疑者は有罪であるというふうな推定を社会から受けてしまいます。そして勾留されますと最大で23日間起訴までの間身体を拘束されるということになります。さらにこの23日間はまた別の被疑事実で逮捕勾留が繰り返されるということになるとこの23日間が複数回繰り返されるということになります。
Katsuzo Nakamura, a tax accountant, was arrested in 2016. He was detained for more than 5 months and eventually charged with violating bankruptcy law.
否認してました。っていうのは訴えた時弁護士管財人は一度も会ってないんです。そして話もしたことない、一度も会ってない人になんで僕訴えられるのとは何度も言ってました。
At the time of his arrest, Nakamura had pancreatic cancer. Without access to the right diet and adequate medical care, his health deteriorated rapidly.
病院に入れてくれっていうことを何度も訴えていても却下されたんですね。一切がんについての治療は全くされませんでした。で、7回の保釈申請却下があり治療を受けられなかった。
罪証隠滅を疑うに足りる相当な理由があるなどとして裁判所が保釈請求を認めないというようなケースもあります。
Nakamura was finally granted bail after 156 days. The Tokyo District Court exonerated Nakamura of being a main accomplice, but found him guilty as an accessory, a conviction he later appealed.
令和1年の5月29日は判決の日で、主人は自分が行けないから3時頃田代先生からお電話をいただきまして判決が出ましたっていうことで上告しますかって言われたらするで金の心配いらないからやってくれ俺は無罪だって言って頼むって言ったのを聞いてその日の夜ですね亡くなったの。
検察官が一旦起訴してしまえば、その 99% 以上の事件が有罪になるという有罪率の高さというのが日本の刑事司法のもう一つの特色です。そういう無実を訴えている無罪を主張している人たちの本来権利が保障されるべきなのに推定無罪の原則というのは本来有罪判決を受けるまでは無実と推定されるんですね。
The Japanese government should ensure Japanese laws can establish a criminal justice system in line with international law. The rights of suspects should be protected, and prosecutors and judges need to stop abusing the law. Koki Takatsu, a construction worker, was accused of child abuse in 2017. He denied the allegations, but was detained for more than 2 years before eventually getting bail.
生まれて1ヶ月記念日の日に意識を失って結局僕が心臓マッサージとかをパニックになっちゃってやったことでその肋骨が折れたりとか大学病院の方に搬送されましてその2ヶ月後の、3月22日に、息を引き取ったっていう形ですね。地獄の始まりみたいな。もう朝5時ぐらいにそのまま警察署入って僕夜7時ぐらいまでずっといました。要はこれ言えば今日帰っていいからみたいなところでなんかそのあっちの意向に寄り添っちゃった意見を言っちゃったんですよ。そしたらそれで提起してもらえて今思えばそれが自白の強要なのかなって思って要はあやしてたことを揺さぶったような方に変換されて
取り調べの場面というのは結局弁護人も立ち会わないで裁判官もいない検察官が一方的に尋問する場です。でそういう場で尋問をして、供述したことそれを本当に証拠の中心として扱っていいのかという問題もあります。
10月の逮捕後は面会もできない手紙も出さない中で周りがどうなったかもわからないまま結局離婚届をいきなり突きつけられて、妻の実家に 警察が追い打ちをかけるようにあなたの旦那さんはこういう人でもうこういうことをやってとか、離婚をした方が絶対いいですよみたいな、そんな人ともういたくなくなったとか言って最後にうちの母に言ってたらしいんで、初めて自分に負けたなと思ったのは自殺したいって真剣に思うようになって。
Takatsu was granted bail in 2019. 2 years later, the Tokyo High Court acquitted him in the final verdict.
本当にここまで長かった。まさか本当に叶うとは 1% も思ってなかった。釈放されたらもう最初の1ヶ月はもう人と一切会わなかったですもん。他の人はもしかして自分のことを報道で見て知ってんじゃないかとか、もうそういう逆に自分が怖くなっちゃって、夜勤の仕事にちょっと行ってみたりとかした時に初めて、今少し自由っていうのはこういうことなんだなって。
So I wish Professor Sasakura would explain a little bit more. She was in the video, but I'm here to speak for everyone about Japan's legal system, as well as she's an expert on the comparison between Japanese legal system and U.S. legal system.
Thank you very much for the kind introduction. My name is Kana Sasakura. I'm a professor at Konan University in Kobe, and I teach criminal procedure law. And I also direct the Innocence Project Japan, which is focused on redressing cases of wrongful accused and wrongful convictions. So the hostage justice system contributes to wrongful convictions in Japan. Looking at past cases, it is clear that the major cause of wrongful conviction in Japan is false confessions. Here we go. I have some simple slides ready. So why are there false confessions, right? So because the focus of investigation in Japan is to get suspects' confessions, so that hostage justice is used to get a confession from the suspects. So the Japanese system allows up to 23 days of pre-indictment detention for each independent charge without the possibility of bail. And the suspects are detained in police cells, notably called Daiyo Kangoku in the international human rights community. During this whole time, it is interpreted by the police and the prosecutors that the detained suspects have a duty to be interrogated, meaning they cannot refuse or leave the interrogation room. So even if they remain silent, the questioning does not stop for hours and hours. These interrogations happen without an attorney present, and until recently, there was no duty to record or videotape these interrogations. Recently, in most serious cases, recording became mandatory, but these consist only 2 or 3% of all criminal cases. So during these interrogations, statement dossiers are made. These dossiers are not a transcript, but are written down by interrogators and signed by the accused. They can be used as evidence at trial as one of the broad exceptions to the hearsay rules. Also, during detention, a judge can impose a ban on communication between the detained suspects or defendants and families, friends, or etc. It is devastating already to be arrested and detained, but you can only talk to your attorney if this ban is imposed. There is no bail during these 23 days of detention, and when the suspect is arrested on another different charge, the 23 days will be repeated. After the suspect is indicted 23 days later, they can apply for bail. However, if the judge thinks that there is a risk of flight or destruction of evidence, the bail may be denied. The risks are interpreted very broadly. For example, if you are from a different country, a country outside of Japan, you will have a risk of flight. Also, if you deny the charges or remain silent, you will have the risk of destructing evidence. All these pressures are designed to bring the accused to their knees and obey what the police or prosecutors tell you to do. It is as if you are being a hostage and only freed when you confess. You are giving up your liberty for not confessing. Innocent people tend to be detained because they will deny the charge. Thus, the situation is called hostage justice. No wonder most of the defendants confessed, and false confessions become the major cause of wrongful convictions. Using these confessions, the Japanese conviction rate is a staggering 99.83%. This slide shows a list of cases which were exonerated in Japan through retrial. When we look at how many of these cases involve false confessions, okay, so it's 21 cases out of 26 cases. So if you compare the situation in a typical felony case in the United States, the distinction becomes very quite clear. Of course, the American criminal justice itself has many problems, I know. But at least I do not think the American system is designed to elicit confessions. When you are arrested, you are given Miranda warnings. You will be taken to a judge within 48 hours, and then you are eligible for bail. Interrogations don't last for days like Japan, and if you decide to remain silent, the interrogation must stop immediately. Your attorney can be with you during this interrogation. So I'll explain some of the cases. One case of false confession in Japan, which is very well known internationally, is the case of Iwao Hakamata, a 1966 murder case and whose retrial is now in progress. This was a case of death penalty, and Hakamada had been detained for 48 years, 34 of which on death row. Hakamata made a false confession because of brutal and lengthy interrogations. This case illustrates the serious consequences that the hostage justice brings. This case was from 1966, but even in recent cases, the situation has not changed much. There are many examples, and Mr. Shimada and Mr. Cavazos today, here with me today, are two of these cases, and you will hear their story later. One another recent case is the case of Mr. Yamagishi. Mr. Yamagishi is a former president of Osaka-based real estate company, Presence Corporation. Yamagishi was arrested in December 2019 on suspicion of embezzling 2.1 billion yen from a school operator called Meijo Gakuin in Osaka Prefecture. Investigators said Yamagishi colluded with the former chair of Meijo Gakuin to steal deposit money gained from the sale of a land plot. He denied the charges and was detained for 248 days. He had to resign as not to damage his company. However, the Osaka District Court acquitted Yamagishi in October 2021. And Mr. Nishi here with us today is one of his attorneys. And we all remember Mr. Gon and Mr. Kelly's case. Gon was detained for 108 days, and Kelly 37 days in solitary confinement, and was subject to intense interrogations. Gon's attorney revealed that the interrogation continued every day for an average of 7 hours per day. Recently, a British court criticized the Japanese practice in R versus Regina versus Chappelle case. This case involves 3 British men who were detained after they flew back to Britain over their alleged involvement in a 2015 robbery of jewelry from Harry Winston in Ginza. Whether the 3 will be transferred to Japan is being discussed in Britain, which does not have an extradition treaty with Japan. In this case, the men's defense has been arguing, defense attorneys has been arguing that the handover could raise human rights concerns, namely the hostage justice. The magistrates' courts ruled last year, that it has concerns about the Japanese system, which have been criticized by reports from UN and NGO bodies and rejected the extradition. So have there been reform efforts? Yes.
I won't go into details, but we have had two major criminal justice reform in these 20 years, but both have failed to resolve this issue. The Ministry of Justice has a web page, frequently asked questions on the Japanese criminal justice system, which was written after the international outrage against hostage justice in 2020. It states as follows. The Japanese criminal justice system does not force confessions by unduly holding suspects and defendants in custody. It is therefore not accurate at all to criticize the Japanese system of being a hostage justice. In Japan, there are strict requirements and procedures stipulated in law with regard to holding suspects and defendants in custody, with due considerations given to the guarantee of human rights. The Japanese criminal justice system does not force confessions by unduly holding suspects and defendants. It is not accurate to accuse the Japanese system of being a hostage justice system. But is this true? The cases I have talked about, as well as Mr. Shimada and Mr. Cavazos cases, suggest the long-standing hostage justice system and in existence has adverse implications for Japanese business and tarnishes the country's international reputation. This system may act as a deterrent for foreign business executives considering relocation to Japan, especially as many non-Japanese citizens become victims of this system. So everybody knows that you are innocent until proven guilty, right? You should be treated as an innocent person. The norm is internationally established, right? But you have the right to remain silent at the interrogations. And this is also internationally recognized human rights. But does the practice in Japan fit these rights or norms? Thank you for this opportunity to speak today, and that I conclude my speech. Thank you.
4 years ago, in March 2020, I was suddenly arrested. At the time, I was a director of Ohkawara Kakohki company, Yokohama-based machinery maker. The president of our company, an advisor, and myself are arrested on suspicion of illegal exporting machinery to China. Police has deemed that our spray dryer machine used to turn milk into powdered milk, among other things, as machinery that could be used to produce the biological weapon. The three of us accepted questioning by police for a total of 98 times before our arrest. Over a span of about a year and a half, we answered every question honestly and signed many written statements. Time and again, I would explain that the spray dryer could not be used to produce the biological weapon. However, police arrested us in order to force confession, locking us in detention and isolating us from our family, colleagues, and society. Police even excluded our actual testimony from their written record and instead fabricated statements. As I lost faith in the validity of the police investigation, I decided that I would remain silent throughout my interrogation after the arrest. Interrogation were conducted every day in closed room and continued for 21 days. Those were no audio and video recording on our interrogation. Our lawyer were, of course, not permitted to present during the interrogation. And we are even prohibited from taking notes. Police would ask us repeatedly, you don't have anything to say? If you are remaining silent, does that mean you have no remorse? Every day entailed more interrogation and pressure to confess. I began to realize how unbearably torturous it is to remain silent. Our detention center was a room at the police station. They were treated like criminals. Meals were served closed in plastic container that they would leave on the floor. I would only use the toilet that was in the corner of our room without privacy. Eventually, I became ill and suffered diarrhea for days. When we traveled outside of our cell, we are handcuffed and restrained at the waist by a leash called Koshinawa. Don't make eye contact with anyone. Keep your head down. I would betray us. They would berate us. Frankly, we are treated like a slave. Of course, like everyone else, we could not email or call anyone. On top of that, court had issued contact prohibition order, meaning we could not meet or even exchange a letter with anyone, including our family. The only outsider we could meet with during the detention was our lawyer. I could hardly handle anxiety that overcome me as I wonder how my family was handling the situation. This new style had deprived me of physical and emotional strength. There were many days that I considered confessing only so that I could leave the detention center more quickly. In Japan, it is only after the formal indictment that one can apply for bail. Hence, I asked my lawyer to request bail immediately after my indictment, which was 21 days after my arrest. However, court denied the bail application on the ground that I might destroy evidence. I realized that in Japan, bail was virtually out of reach without confession. Again, I would request a bail only to be slapped with more denials. Finally, after 6 applications and a total of 332 days in detention, we are arrested on bail. In July 2021, 6 months after our release, there was dramatic turn of the events. On that day, a mere of 4 days before our first trial, prosecutor withdrew their indictment against us. They said that it was difficult to establish the exports of our spray dryer machines violated the regulation. In other words, there was no crime. Given all of this, we sue for damage taking Japanese and the Tokyo government to court. In its decision last year on December 27th, the Tokyo District Court declared the arrest, interrogations, and indictments illegal, awarding us damage of 160 million yen during the cross-examination. Current investigator in Metropolitan Police Public Security Bureau, the police division that arrested us, admitted that the case was fabrication. We are only able to remain resilient throughout the 11 months of brutal detention in the knowledge of our absolutely innocence, as well as our unbearably commitment to prove our innocence in court. Japan conviction rate, however, remaining extremely high at over 99%, even for those like us who are innocent. Far too many are likely to be forced into confession, as that is often only way to flee the harsh detention. Furthermore, we have to prepare for trial under the cruel detention and isolation from family, friend, co-worker, and society. We had cooperated closely with the Ministry of Economy, Trade and Industry, exchanging document and communication that detail what kind of machinery applied to their specific regulation. All of those files had been confiscated by the police, and it was further complicating to try to locate them for our defense as we are isolated in detention. I must emphasize that to end of first conviction, it is essential that those who claim innocence can be defend themselves in an even playing field with powerful authority. In closing, I would like to highlight the irreversible tragedy that this hostage justice can breed. Mr. Shizuo Aishima, the advisor who was arrested with me, was likewise cruelly detained under total fabricated charges. He was diagnosed with stomach cancer during his detention, but he was neglected of adequate medical care and unfortunately passed away in February 2021. He applied for bail 8 times, but never granted one until his death. Once we are proven innocence, let's go have a drink. The conversation before our arrest became my last word to him, and sadly never came true. Our Ohkawara Kakohki case have been reported extensively in Japanese media. However, this case has not been spurred any independent inquiry or reform by the Japanese government. That would only allow false accusation and hostage justice to endure for future generations. I call for an end to the hostage justice system, which justify long-term detention, family separation, and psychological torture to force confession. I also call for reform for that at the very least, police and prosecutor respect the right to remain silent. Lawyers are permitted to join their client during the interrogation, which should be recorded on audio and video. I thank you all sincerely for your time and ask your support in ending injustice in Japanese legal system.
So my name is Marcus. I'm an American expat. I've been in Japan for a little over 13 years. It's been 5 years now, or almost 5 years, but back in October 2018, I was arrested. initially, the reasons for this arrest were not very clear to me. Even upon being taken to the police station, between the mixtures of language and different laws in this country, my comprehension of what was happening was still not exactly clear. But what happened and what I was being charged with was that during the earlier period of October, I had a friend who had been living in Korea stay with me for about a week. And during that time period, he was traveling around Japan, and he requested to use my address to receive a package. This is someone I had known for about a year, and generally speaking, I like to see the best in people. So yes, I allowed him to use my address, and I received the package. And later, when he was in Tokyo once again, I gave him the package. And I had received many things in the mail before from my mother. As a foreigner, I know that when mail does come from overseas, it is checked by customs and seen if it was safe or not. And very clearly on the package, it said that it had been checked by customs. In this case, I felt that it could be trusted, and that if there was something wrong, then the Japanese law would actually help me. This was far from the case. I was arrested, and I was accused of drug smuggling. What actually was inside the package, or what had been removed from the package by customs, was methamphetamine, or crystal meth. This was actually my first experience ever being arrested. I've never even had a parking ticket or a speeding ticket. But unfortunately, I did want to cooperate and listen to authorities. So I told them exactly what I just told you. And they said, much as you've heard in all the other cases, they said if you sign this paper, it'll go a whole lot more smoothly for you. The thing is that when you do sign one of these papers, it's not you who wrote it. It's not you who wrote a confession. It has been worded by a prosecutor or a police detective. And the only benefit of signing said paper is so that they can use this as evidence against you in a court of law. So there is no benefit of signing anything when you're arrested. Of course, I was not even allowed to see a lawyer before meeting with detectives or the prosecutor. I signed this paper, and later I refused to sign anything further. So I sat in a cell, much similar to Mr. Shimada here, for 23 days. I was then released, allowed to leave, and then immediately I was then rearrested and then held for another 23 days. The lawyer who I'd been seeing, who was a court-appointed lawyer, he assured me that, well, things will probably actually be fine. There is no evidence. It's just the case itself, this accusation is too abstract. They're going to have to prove that you knew what was in the package. But after another 23 days, when I was assured I would be released, I was not. And instead, I was indicted over the first paper I had signed. They viewed as a confession. And what was actually written on what I signed was not what I said, but it did say that I held a thought or a suspicion that methamphetamine was in the package. I did not say this, but the prosecutor wrote it on the paper. So from there, I was put into solitary confinement until April 2019. Although I do think that the treatment of people in this case is not nearly as bad as other prisons in other countries, it is psychologically damaging. So I sat in a cell, probably about the size of that bathroom down the hall, and I was alone, and I could not communicate with anyone. And their exercise time was twice a week, but only for 15 minutes. So as you can, otherwise you sit in the cell. So my health greatly deteriorated. After, when April came, my lawyer, who was in this room, I was able to get bail. But upon being released on bail, like the little things in life, like riding a bike or walking, were very difficult after so long in a room by myself with no exercise. Going to a place like the movie theater or the game center was actually very traumatizing. You're just not used to anywhere that's noisy or anywhere that has lots of people. Eventually, we went on to win the trial, but no amount of reparation, money, or apologies can make up for what happened to me. It's still something that gives me PTSD today. And I probably will never have much respect for any kind of lawful authority in this country again. So mind you, I still love this country, and I'm still here, and I plan to remain here. But these things do need to change, and I hope that by speaking here, that there can be a difference. So by hearing my story and Mr. Shimada's, things can change. So, yeah, thank you very much. So.
Shimada-san and Marcus, thank you very, very much for your frank and bold statement and clearing things up. Wanted to open the discussion as quickly as possible. I would like for the professor, and thank you very much for all your good work. Just can you explain to us a little bit of the history of the criminal justice system? Because again, I am not a lawyer, but obviously, during the American occupation, a lot of rules and laws were rewritten, and were written in the, shall I say, American spirit, right, of accountability, of due process, and a lot of good things have come out of this. How come that the criminal justice system, in Japan is so very different from the criminal justice system that we have in the United States of America?
Thank you. That's a very good question, Jesper-san. So originally, the Japanese criminal procedure law was a French influence in the Meiji era, but it became it had a German influence in the Taisho era. And then after the World War II, it has imported some American spirit. But it's so half of it is just like German, and it's like a mixture of the two legal systems. And since before the World War II, there were, the very inquisitorial system. But after the World War II, we actually imported the American system, but it did not, change the whole system. So there's like a huge rock of this, very inquisitorial system beneath our, due process. So I think it's like a mixture. So I would say that there's a history of this, mixture of these legal systems, and so it hasn't basically changed the mindsets of the police or the prosecutors. And so, what would you say? Yeah, I would think so. Yeah.
Interesting, right? Because I mean, technically, you do have bail, right? But the reality of the application of the law is that both the police and the prosecutor, run the show and are very much empowered, and that in reality, the human rights of the individual are basically non-existent.
Right. So I think I think that the Japanese code of criminal procedure is not that bad, but the application of these rules are very bad. So that what brings into this hostage justice.
Peter Landers from the Wall Street Journal. I wrote a story about false confessions in I think 2000 for front page of the Wall Street Journal, and I honestly didn't think that we would be here in 2024 having the very same discussion that I had with lawyers who I talked to 24 years ago. But here we are. As you said, there have been some reforms, but the core of the system has not changed very much. And so my question is, what type of, what is the next step? What is a practical, realistic type of reform that you think could actually be passed by parliaments? So I guess I would address it to both Sasakura Sensei and Mr. Shimada.
I mean, before Shimada-san and Kawaso-san, maybe I would like to present my views. Yes, it is a big challenge to bring in the reform in this area for many reasons, including despite this reality, the faith into the Japanese, judicial system, faith into police system, prosecutor system, I think it's quite high among Japanese people. And I don't say that they are doing bad job only, but in this particular field, rights of suspects in pretrial stage is particularly bad. And also but among others. But anyway, but I think reform is possible, mostly because there were no movements or no advocacy towards the Japanese government, towards the Japanese diet, concerted efforts to bring justice, to bring a reform on this system. Of course, there were some reforms in the past, but this was triggered by scandals, not by their efforts for reform. Yeah, and then so that's something we are aiming for the first time in the last whatever decades. We are trying to make concerted efforts to change the Japanese hostage justice system, and then on top of it, I am sure that scandals would happen again and again because the system is still this, abusive system is in place. So, if we try seriously, I think the reform is possible. And then on reform, I think that the current system doesn't allow bail for those suspects who do not confess. It's very difficult. So this system should change, and I believe can change. Lawyers should be present during investigation. Audio and video recording should be mandatory for all cases, not only 3% of cases, as well as their interrogations should stop when suspects exercise the right to remain silent. On top of it, communication ban order should end, which prevents suspects to communicate even with family members. When they communicate with their family, when they meet in police cell, there are police officers present. So if they want to, they are monitoring all the communications, and so that should be allowed, particularly for family members. So those are the reforms we are proposing, and then I think it's possible.
So my English not so good, therefore I speak in Japanese and she translate. 私が思うには少なくとも弁護士の立ち会いと、録音録画がぜひ必要だと思います。
At the very least, I think that the presence of attorneys at interrogations and also the audio and video recording of all the interrogations is needed.
少なくとも、録音がすべての取り調べにおいて認められるべきだと思います。実際に今回の私の事件においても私は自主的に録音しました。40回の中で。
And at least I think that all interrogations should be audio recorded. In my case, my 40 interrogations, I secretly recorded it.
それが証拠となってそれが冤罪をファブリケイテッドだということの証拠になりましたので、ぜひ そういう被疑者においてもそういう権利があれば冤罪がなくなると思います。
And these recordings, audio recordings, became evidence in my proving that this case was fabricated. So I think it should be admitted or allowed in every cases, every case.
I do think that a level of leniency on bail or the overall situation for people that have been indicted should be improved. Like I said before, I was in solitary confinement with very little exercise, and miraculously, I did get bail. However, it is very obvious of what the prosecutor and the police want to do. They want to make you weak, both physically and mentally. If I had not gotten bail, the prosecutor had wanted to actually have the trial later that year in August. But when I received bail, then suddenly he got a bit nervous and said, "Oh, we should have it in June." But if I had not gotten bail and I had just gone to trial as a weak, psychologically defeated person, I probably wouldn't have won. So, thank you.
Can I just add that I think, generally speaking, I think the courts or the judges should have more control over the situation, and I think they should proactively guard the human rights of the suspects. But this is not happening. So I think the Japanese criminal justice system is, ruled by the prosecutors. So we call this a prosecutor's justice and not the judge's justice. So once you're indicted, you're 99.83% to become convicted. So that's not normal in a democratic society, right? So in like reforming the interrogations, allowing internationally recognized rights, maybe like Miranda rights, and also the length of the detention should be lessened. So I think these are the reforms that we could realize.
Thank you very much. This may turn out to be more of an observation than a question, but Shimada-san's story is chilling. There is the new economic security law, which will be implemented or come into effect in May. And you mentioned in the introduction the economic effect. My company employs 13,000 people here in Japan, and we are thinking about how do we implement what is actually a very vague law. The contents are unclear, but I think as a result of Shimada-san's story, I shall be adopting an abundance of caution. And that will lead to things such as workplace apartheid, where we cannot have Chinese individuals working on certain projects, for example. So I'd be interested in your observations about how companies should address the new economic security law.
経済安全保障について、特に武器輸出だとか、その武器の転用について私は非常に賛成でして、でそれを厳格に進めるには法律の明確化がぜひ必要だと思います。
I am for this economic security laws, and I think namely the prohibition against arms should be imposed, but I think the law should be more clear.
でそれが明確であれば平和に利用されるものは間違いなく輸出できますし、でその武器に転用される危険なものは輸出されなくなりますので、ぜひそういうふうな法の明確化がぜひ必要だと思っています。
And I think the legal words should be more clear, so as not to, put a ban on exporting peaceful materials, and not importing. Not exporting prohibited dangerous material arms.
実際には国際的に決まったそういう規則があったんですが、日本の その法律に置き換えるときに非常に曖昧な文章になって、それが警察が勝手な解釈でものを進めたという原因になったと思います。
So first of all, there is an international rules which are clear, very clear. But when importing these rules into the Japanese law, the legal wording became very vague. So this was why the interpretation of the Japanese laws was, misused.
Thank you so much for your time and for sharing your knowledge. I mean, I am truly moved and by Shimada-san's story and Marcus for being brave and really sharing such a heart-wrenching story. But also as, well, two questions. One is, so do aspiring lawyers that take the bar, are they aware of all these situations? You would think so, but I'm wondering when they go to law school or when they're studying, I guess, Hogakubu, are they aware of these situations, and are you teaching them in university and graduate school? Is one, because I think awareness should increase, and I know the Japanese bar is so hard to take compared to the United States. I think it's so the level is just so much higher. So within this, can we reveal that? And I was actually, fascinated about Carlos's Gon case because it became an international phenomenon. And is it possibly Gaiatsu that's going to bring more pressure on Japan? And is that one of your objectives? And then also the second question is, people like me and my husband who are visiting, but also, have a really close Japan-US relationship, what can we specifically do, or the local common Japanese person, can they do to help this cause and bring it to showcase the situation?
So much. Excellent question. For the first question and then for the last section of the question, I think that definitely the Gaiatsu will bring change to this situation in Japan. And for the first half of the first question, yes, I definitely teach my students about this. And so my school is a very immediate private school, so not many students go to law schools, but they are. I think some of these students become very aware of the situation in Japan, but it's not enough. It's not enough, so we have to involve the whole community, and also I think the lawyers to be are pretty aware of this situation, like Hitojishi Shiho, the hostage justice. But and so I think one of the problems in the criminal justice system is that there are not many younger defense attorneys who wants to do criminal defense, because you're up against this 99.883% of conviction, so you never win, right? So I think the criminal defense attorney, they can speak for for this question, but I don't think it's a very popular job. So many, aspiring young attorneys would go to bigger lawyer firms. So I think one of the problems that we have is that,
we really need Gaiatsu, but we are, I mean, of course, change comes from within. So we are working really hard. However, this is such a serious human rights problem, which is, continuing for decades. So we wish that it is going to be the international issue, as well as it is affecting not only Japanese citizens, but also anyone in this territory. So I wish everyone speaks up, because this is a human rights issue. And then, by the way, whether law students are aware of this problem, Professor Sasakura is such an exceptional professor. I am one of the very ordinary, I think, students, 20 years ago, but I don't think that the situation didn't change much. I was someone who was not aware about this situation much. Kind of vaguely heard, but I was not really aware of this seriousness. So when I met the person in detention who was in fact innocent, I was so shocked. And then, in fact, I was not able to win because of this 99.8% conviction rate. My spirit broke down, in fact, and then I realized that I cannot be a criminal defense lawyer. So I have enormous respect for those, three lawyers who never give up. Wow. Yeah, not only defendants, but accused, but also lawyers need extraordinary strength in order to keep up this job.
So this is a question to Shimada-san. Why do you think the police went after Ohkawara Kakohki? The idea that you were sending weapons to China sounds quite absurd. But did they genuinely think that? Or did they incentivize to arrest as many people as possible?
かなり、その機会は世界40カ国に、何十台も輸出してました。
The machinery we produced was imported, exported out to 40 other different countries.
しかし中国へ輸出した機械だけを取り上げて、これがイリーガルだと言われました。
But they pointed out to the machinery exported to China only.
でその理由は私はもう推測でしかないんですが、何か政治的なバックグラウンドがあったんじゃないかと私は推測しています。
So this is just my guess, but I think it had a political background. This case.
What do you think is the real problem about the situation here in Japan? I think we talked about the reforms that we could do, but what do you think is the underlying issue? More of a general question about Enzai.
It's a good question. There are so many problems, but if I need to choose one, the suffering. There is so much suffering for those who didn't commit crime, who became suspects. But I think the core is really the denial of liberty. So when you do not confess, you're going to be detained. Your detention is going to continue. That really is the core of the problem. So the international law says that they're taking the liberty, depriving the liberty of suspects should be the last resort. So that should be implemented here in Japan.
One other problem that I can point out is that, Mr. Shimada-san touched upon this, but so once we make mistakes, we don't review the situation and improve the system, and there's no inquiry. In Ohkawara Kakohki's case, as well as Mr. Cavazos' case, there was no inquiry by the government or the prosecution's office or the courts. So this repeats in many other cases as well. So I think that we should, definitely, if someone makes some mistake, we should, review and make improvements. But this does not happen in Japan. So yeah, I think that's one of the major problems.
Reed Stevenson from Bloomberg News. Really anyone in this room could be arrested today or tomorrow. So I'd like to ask the panel, but also maybe the lawyers in the room, what advice do you have for anyone who's arrested?
Don't sign anything. Sign nothing. You can talk, but if you sign something, it gets used as evidence in a court case. So don't sign anything.
Yeah, and don't you think that you should remain silent at first? But yeah,
well,
maybe Ms. Wada would like to talk. Yeah. Okay. Yeah.
It's recorded, but the actual recording is not the evidence. It's the signature on the paper that acknowledges that what the prosecutor wrote down is what's going to be used against you later.
Yeah, statements can be evidence, but only talking wouldn't be evidence against you in the court. However, usually it is very difficult when you talk. They pressure you to sign something, and then Japanese, culture maybe is very difficult to deny those, oppose those pressures, and people eventually would sign. Many cases, you were pressured to sign something for 23 days, for hours. It's very difficult to oppose it. So I think that many lawyers in Japan, in fact, advise you to remain silent in order to escape from such pressure. But still, even you remain silent, there are lots of pressure, but less pressure than talking. I guess that's, but lawyers can.
When do you get your right to have access to your lawyer?
You could have access to attorney if you know one, and you could call the bar association. I mean, you could ask the police to call a bar association.
But I mean,
they could.
at the most important stage, you don't have access to lawyers. You know, when you really need lawyer, that's when you are investigated. Oh, sorry, you are interrogated, when you're questioned. But at that stage, you have no access to lawyers. But when you go back to your cell, they can visit. I mean, lawyers can visit suspects and they can talk, but not at interrogation.
So we all have to become lawyers.
Yeah, maybe self-defense.
I mean, you could call the bar. I mean, you could ask the police to call the bar association and to send a lawyer. There's a volunteer system called Toban Bengoshi Seido, and you could call one, and you could also, make connections with these guys in the room, and and ask them to come immediately when you are arrested.
My name is Konan. I'm here from the German embassy. I have 3 quick points. First of all, what do you think is the motivation? Because I don't see any benefit, like financially or prestigiously, in there. So what is the motivation for prosecutors, for police, to go about this 99.8% of conviction rate? Second of all, is this something that has been known to the ordinary citizens? Do they know? Is that something that's discussed publicly? Because I would feel that if people knew, there would also be more of a movement to abolish that. And thirdly, as has been mentioned, Gaiatsu, so there is, as was mentioned also, the tradition of German law in Japanese that made it into Japanese law. So we have an exchange, justice exchange. So is that something we should include, at least raising awareness in there? I guess I know the answer, but still, thank you.
You do the follow-up?
Takehito from Sophia University. My question about the prosecutor perspective. Sasakura sensei, you may teach students who will be prosecutor or attorney, which will be protecting people, but what makes prosecutor to be so harsh? Is that they're a prosecutor community, or what kind of expectation they're following in Japanese community? Thank you.
Well, to answer your questions, so the prosecutors or the police thinks that Japan is in fact the safest country in the whole world, right? So I think they are good-heartedly wants to to keep this the safe country. So I think there are some good intentions, and so they would like to and they think that the Japanese system is the best in the world. So I think there's no would you like to say something, or so they think that it's the best time in the world, so and they think that they will never make mistakes, so that's why there's no review, etc. Yep.
I mean, this perception of, it's not broken, therefore there's no need to fix it. In terms of public awareness, I can only tell you a personal story with Doi-san. After they published the report, we've done a couple of sessions not in Tokyo, right, in Osaka. And, when I talk about this to my Japanese friends, they don't know. They do not know. Right. And as you know, I mean, dealing with the law, being in any way, form, shape or another implicated in something that has to do with the law or the police, it's like you become murahachibu, right? You become an outcast, you become shunned by your friends and society, very, very quickly. And that, of course, is the devastating element, because the moment you are being detained and you are stuck in that hole, you basically, become an outcast, unless you have very, very strong family ties, right? So I think that, the destruction of real, inochi, of real human beings, right, of families, that goes on day by day, month by month, year by year. Here is something that needs to be brought out a little bit more into the open. In closing, and we could go on for a while, please do have a look at the Human Rights website. The the pamphlet here with the wonderful manga, is there. We thought we were going to have the English version of this document ready for distribution here, but somehow, the Yamato Unyo didn't deliver on time. But the copies are there. It's very, very good reading. One final comment from my side. It is very clear that it's not just because Japan is internationalizing more. There's now 3.2 million non-Japanese living in the country. Last year, we had about 350,000 of net immigrants. It's obviously that a more transparent and fairer and more global standard-based prosecution system, is absolutely necessary. But on top of that, given Japan's place in the world, Japan should be ahead of everybody else. Japan should pride itself of indeed having the best justice system, the best prosecutor system here, so that it gets adopted and becomes the envy for other nations, whether they're in Asia Pacific, whether that's in China, whether that's anywhere else in the world. So the aspiration of really being the best in the world that sets a new global standard, I think is going to become more and more imperative, as the world, looks for proper leadership, for something that can be respected. And Japan, as we all know, we all love it. There's so many things where Japan is so respected, where Japan really is the best in class and sets the standard. This is an area, right, where a lot of work needs to be done. And ironically, it doesn't take a lot of things, just a little more focus on human rights. And I'm very happy to report, and you are very hazukashi, I know that since the publication of the report, right, Doi-san, has made some good inroads, within the Japanese elite, within the people who, hopefully are going to, who certainly are in a position to bring about a correction of the system there. Every little bit helps. How can you help? Get engaged. Get engaged with Doi-san, always fun, right? Excellent karaoke singer, right? The work that you're doing, I mean, the team, that you have been building here. There are some other organizations that, we at the Asia Society are also very, very happy to introduce you to. Let's start a movement. Thank you very much. And most of all, a very, very big thank you for, Marcus, Shimada-san, everybody here, the other legal team here. We look forward to maybe doing a repeat session at some point in the future. And best of luck and best of success for all the good work that you're doing. Thank you.